Let's soldier on, as our vice chair likes to say. Um,
Okay, so we are talking about Act 250 amendments that are currently in S226. Next, in Section 2D, it's looking at the Criterion 1D, which was one of the last sections of 511. It does use different language than what is in 511. It is not proposing to change the definitions. However, it is adding a new provision starting on line 11. And I do think this is probably related to housing. So Criterion 1D is used for any permit under Act 250 review. It's asking the permit applicants to look at flood hazard area, floodways, or fluvial erosion areas, or the floodway fringe. And so down on line 11, notwithstanding subdivisions 1 and 2, within an existing settlement, which is a defined term in Act 250, a permit shall be granted if all occupied space is elevated or flood-proofed at least 2 feet above base flood elevation or otherwise designed to be reasonably safe from flooding. This is different than what is currently in the statute. Currently, the statute asks that if you're going to be developing in one of these areas, you have to demonstrate that you're not going to be restricting the flow of the floodwaters, causing endangerment to health and safety, and you'll not contribute to or increase the discharge during a flood. So this is actually adding like an extra almost escape hatch provision, saying, notwithstanding if you might restrict or divert flow, a permit will be granted if all occupied space is elevated and flood proofed.
Does that mean, I mean, we're going into other committees' jurisdictions probably, but does that mean that you could build and it says it shall be granted? So I'm thinking that someone could get a permit just if they meet those requirements, regardless of whether there are other adverse impacts. I mean, if you redirected the river and it flooded another area, it seems to read, well, I don't care about that other area. I got my permit.
Yeah, I do have concerns that this would potentially interfere with other criteria. So if you want to pursue this language, I might want to try to sync it up with some of the other criteria in the statute, but yeah, this is pretty strong language.
Okay.
Yeah, and shall might be may. Yeah, I hear that. No pride of authorship. Don't want to cause a lot of undue damage.
Just a first run through. So.
Okay, and so this is a section Senator Rahm Hinsdale hinted at before, mitigation of primary agricultural soils. So currently under Act 250, if an application for a construction project is going to impact primary agricultural soils, there is a requirement that they mitigate that impact. Primary agricultural soils are mapped, and the Agency of Agriculture, excuse me, does administer this part and does weigh in on this when an applicant is going to reduce or destroy agricultural soils. So currently under that program, depending on where the project is going to be located, an applicant may need to do on-site mitigation, which would require the applicant to either change the shape of their project to avoid the agricultural soils or reduce the size of it. It does refer to sort of physically altering your project to avoid destroying the soils. There is, however, in designated areas, so within the downtowns, growth centers, new town centers, and NDAs, the applicant does have the option to instead do off-site mitigation, which is essentially paying a fee based on the number of acres of soils that would be destroyed. And that fee then goes to VHCB, who would then purchase and conserve similar land elsewhere that should be protected for agricultural use. Anecdotally, some of the developers prefer to use the offsite mitigation because it's a calculation they can do and they don't have to alter the dimensions of their project. But there are pros and cons to both methods. And so this is making an amendment here that so it's extending that this option for off-site mitigation, so the payment of the fee, is being extended to neighborhood development areas in village centers and new town centers, because currently it's only allowed for those around downtowns. So that's
What is the date change? Does that mean that they've allowed sort of a grandfather clause and we're getting rid of that? So now.
So I think this provision was added in 2013. And so at the time there were already existing new town centers, and this would be moving. And so it was moving forward. This would be allowed. This is striking that requirement and saying any new town center. There currently are still only 2 new town centers, and I don't actually know off the top of my head the date of their designation. So I think it's just removing that sort of date requirement that was initially required.
Okay.
And then additionally, still in this, so on page 15, for a priority housing project or an alternative or community wastewater system located in a designated area, the ratio shall be 1:1. And so this is for the calculation of the mitigation. For all other projects currently, the calculation is based on a number of factors, and the Agency of Agriculture works on this with the district commissions to do a calculation for how much agricultural soil needs to be protected. It's usually somewhere between 2:1 to 3:1. And so this is lowering it to 1:1. And then finally, in this section, there is a mitigation flexibility provision. So for, I believe this is for, again, the designated areas. Yeah, so for designated areas, the district commission who's working on the application has this mitigation flexibility to allow a combination of both on-site and off-site mitigation. And this is striking that provision so that the default will just be off-site mitigation.
I'm not, okay. So does this promote more development, or? It seems like it's restricting the flexibility, right?
It's striking the flexibility so that the district commission can't require the on-site mitigation, which would require the shrinking of the project potentially. So it would just say, district commission, you are required to assess the off-site mitigation, which is just a fee that is paid by the developer that then goes to VHCB, as opposed to saying the combination of a fee versus shrinking the project.
So this liberalizes development, I think, right? By striking this.
Potentially.
Okay.
Potentially, yeah. It expands opportunity.
Okay. Yep.
Okay, I think this is the last section. I'm on page 16 of S226. Back to Title 24 in the municipal bylaw section.
Right.
Oh, yes. So this is the on a completely different note, this is a requirement that essentially would get rid of single family zoning. So we're in the zoning bylaw section, and we're striking language regarding requiring towns to include multi-unit dwellings somewhere in the town. And we're adding language here that says, in any district that allows residential development, no bylaw shall have the effect of prohibiting multi-unit or multifamily dwellings.
Okay. So I think we had this in one of our bills and we watered it down somewhat to something to deal with the character of the neighborhood. Is that
Yes. Yeah.
correct?
Yeah.
So no,
Okay.
kind of. So you in S237, there was a proposal to allow duplexes ubiquitously but only in designated areas. This is for any town with zoning has to allow multi-unit or multifamily dwellings in all of their residential zoning areas. They can't restrict multi-unit dwellings to specific zoning districts, which is how the law currently works.
Okay. Something did get enacted with dealing with this, with the character, something about,
With the character of the neighborhood.
Yep. So currently, towns are allowed to require conditional use permits for multi-unit dwellings. And you did add language that said they cannot deny a conditional use permit for multi-unit dwellings based on character of the area.
okay. And do you recall, was there a middle ground between that which passed and this? This is obviously very strong. We'll get into this. I'm sure there's going to be some objections to. Did we start out with something and compromise with the House or something that was in this same context that we had proposed something more than just the character of the neighborhood, but less than this?
So off the top of my head, the only provision again was the allowing of duplexes in every district,
Okay.
as opposed to this is any size apartment building or structure. You did have language regarding allowing duplexes in any residential district.
Okay. So you read this to be that a town couldn't have a zoning law that said duplexes are allowed in any zone, but anything more than a duplex could be prohibited in a zone. That would, I just try to understand what this language means. I sort of read it initially that if they allowed for duplexes, it would meet this language.
So that is a fair point. Multi-unit and multifamily aren't defined. But I do think the statute, and I can double check on this for you, I do think the statute also uses the word duplex. And so I do think it's a difference. We can add definitions if you want to be more clear here.
Well, I mean, in the broadest reading of this language, I guess if somebody wanted to go into what is now zone 1 acre for a single family and said, well, now this law passed, so I'm going to build a high rise in there and you can't stop me because all multi-units are now, you can't prohibit any multi-units. So, I mean, I think that I don't think we're trying to suggest that. I think we're trying to say you can't have single family. You got to allow something more than that, but not anything.
Right. I would agree with that, Mr. Chair. We don't want anything, but we certainly want more density. And multi implies more than a duplex, in my humble opinion. But you're right, Ellen, we haven't defined it.
Okay.
And we'll need to.
Okay.
So this, I agree. It maybe isn't the perfectly clear. I would also add though that it didn't get rid of the requirement that a town could add a conditional use permit. Like we just talked about with the character of the area. So they still might have the option to require some permitting, but they couldn't fully prohibit.
So Ellen, it's the witching hour, 10:30.
Yeah.
Should we let you go?
Sure. And so just quickly, the last page of this is this is a task force as opposed to hiring a consultant. But again, it is asking for a review of the designation program and updating it.
Okay.
And Mr. Chair,
Yes, Senator Clarkson.
is Chris still with us? No, Chris
He
is
said
left.
he said he'll be back at 10:30.
I know this.
I've rejoined.
Yeah, no, I would hope that actually, as we go through this, that we would expand this to be a task force that would look at all the designation programs in housing, just because I think, just as I mentioned earlier, why are we adding more programs instead of expanding the jurisdiction of one we have that everybody can apply for that don't seem to be as many challenges with. So I actually think this is near and dear to Chris's heart, doing a review of all the designation programs. Isn't that correct, Mr. Cochran? Yes. So I would hope if we go forward with this aspect that we would include all the designations, designated programs.
Great. Ellen, thank you so much.
You are welcome.
We'll see you next week.
Good luck.
Okay. Is David with us?
He is.
Indeed.
Okay. So David, help me out here. Are there parts of this bill that you have drafted at all?
Yeah, there are a few.
Okay, can we go through those?
I think
Yes.
section 3, beginning with section 3, maybe.
Well, I think we could begin with section 1 if we're still talking about
226.
226. I know you all, you've been around a long time, you know how this works, but I'm sure it must remain frustrating for you to think in your minds, housing and see my face, and then I show up and I have to tell you that I don't know what's going on with 90% of what you're discussing. And I'm sorry for that. That's a silo problem. And just like state government is divided, just like committees of jurisdiction are divided, our office is divided, and there are so many overlaps. Actually, have identified yet another attorney who has worked on a part of this bill, which is Damien. So I'm going to do my best, and I'm going to try to help as best I can. I'm also going to tell you this, of all the things that you were discussing in the context of this omnibus housing concept, some of them have been around for years and are extremely well refined. And, as some of the stuff Ellen talked to you about, the difference is really the nuance in words, right down to the word side of the page. Some of the other stuff goes to the completely opposite end of the spectrum and is just conceptual in nature. And, I think you're at the stage with some of these proposals where you're going to be talking about words, and you're at the stage of some of these proposals where you're going to be deciding, do we want to explore this idea further? If so, we need to work on what it really means. And that's a lot of my stuff, unfortunately, but I'm gonna try to take you through that and do the best I can. So apropos of that introduction, section 1 here is this concept of municipal and regional land banks. And this came as a conceptual proposal from the realtors. Not sure exactly the name of their organization. I don't want to misstate that, but that's the source. The proposal didn't come with bill language so much as a memo that sort of described what they hoped to accomplish. I took that and created the language that's in this bill based on the ready districts. I don't know if you remember working on ready districts, but these are the sort of the rural economic development and infrastructure districts that were designed so that small towns could work together and create things for, telecom, broadband, but could it be for more than that? Could be for other types of infrastructure and economic development purposes. So, as far as the words go, I'm not sure there's much value in trying to read through this language verbatim. I'll say conceptually a few things. My understanding is that this proposal is modeled on activities that are going on maybe in the Midwest, where there is depopulation, there's vacant property, and the answer in some places has been to authorize the creation of these municipal or regional boards that are quasi-governmental entities, the purpose of which is to be able to identify, acquire, and then just transfer basically blighted properties or properties that are underperforming. There's a lot of room for flexibility in here, but at the end of the day, this is this would require statutory authorization for one or more municipalities in some fashion to authorize themselves to create one of these land banks. And again, you would vest this land bank, whether it be municipal or regional, with certain powers. And that could mean things like priority for, purchasing properties that are up at tax sale, like they get an exclusive right to make a bid for the property if it's been foreclosed upon or there's been a tax sale upon it. The authority to condemn properties, perhaps, and then sell them or lease them. Basically, the purpose of one of these land banks would be to, again, identify and then do something productive with properties that are not currently productive. There's a whole lot of details that would need to be ironed out, and there are problems like, who's going to pay for this, who's going to do the work, what should be the basis of authorizing these groups, what powers should they actually have, how much authority you want to give them, do they need money, should they get priority for these properties, should they have the power of eminent domain, what do they do with them once they have them, etc. And then, liability issues like, what if the property is contaminated, it's a brownfield or it's a surplus site, those types of things. Lots of details, but that is the concept underlying the land bank. I'll stop there and see if anybody who else wants to comment on this.
On this one, I think we will have the realtors in next week and have them defend this proposal, unless I would assume that Senator Rahm, you're not in a full position to start answering those kinds of questions. So, I'd be very interested in hearing success stories and, laws or programs we could replicate, if at all. If this is sort of not fully baked at this point, it may be more than we can handle. But, as I've said repeatedly, the idea is to throw ideas out there, whether they're in statutory form that's general or specific. That will depend upon a case by issue, proposal by proposal basis, and whether we want to continue with it or not. So, I mean, it's an intriguing idea. I've invited everybody to come up with creative ideas. I don't know if the Vermont realtors can point to a municipality in Vermont that would want to take advantage of this. So there's a lot to be discovered or explored in this area. And I think we should start with the people who have brought it forward for us. I don't know if you have any thoughts on that.
Yeah, I mean, I'll let Senator Clarkson speak up. The only thing I was going to add, I think that's exactly right. And as a curiosity and the possibility that it may be another tool in their toolbox, a few towns have reached out to me, and I've copied the realtors just to say, let's get on the phone so I can hear you explain how this might add value. to these towns and communities before they come in, just because, yes, a lot of towns are now intrigued to see if this does give them flexibility and, some forward momentum on blighted areas. But, want to make sure I'm not in a position to defend it as fully as the folks I think have seen this
Right.
operating from colleagues in other states.
Yeah, exactly. So we'll have them in. I don't think we need to spend more time on that one, David.
Okay,
Did-
And may I just add, Mr.
Yes.
Chair?
Yeah.
Some towns are doing a version of this on their own. And so I represent a couple towns that are already working on projects like this and creating opportunities for exactly this. And some towns are just having to do it by ordinance, and by special referendum. And so there's a whole range of the way people are trying to get at this. So I think beginning with the realtors is great, but we can also have some other examples testify of how they're solving these challenges.
So you and I will talk. We can identify some of the towns you're talking about and maybe have them come in as well. Okay, moving on.
okay. So I have received word, I've asked if it's okay that I push off my other committee meeting until 11, and I expect I'll need to be there for about 20 or 30 minutes, and then I can come back.
Okay,
So if that works for you guys, then I can try to do high level overview type introduction to the concepts for 20 minutes. And then I can come back to you at 11:30 and talk about this and talk about 157, if that's okay.
okay, that's perfect. Thank you for suggesting that. Let's go.
All right, so section 3, COVID-19 funding, housing, smart growth principles. So this is a pretty simple section of session law, but it's got a big point, which is this. There's all this money going out, obviously hundreds of millions of dollars in housing money, planning money, design and implementation work on all these different components related to housing. And this section basically is a place to say, everybody who gets some of that money needs to the greatest extent possible design and implement award funds that in a way to ensure that they are consistent with smart growth principles. And some of those principles are listed here: compact, sustainable infill development, preserve open natural space, protect natural resources, accommodate a variety of safe, affordable transportation choices, and expand the range of affordable housing. So, obviously this could be fleshed out and be more specific on how it would work, but I think, people like DHCD, VHCB would have a lot to say about how this is implemented and what they're doing or not doing to be consistent with the purpose, which again is to ensure that this money is spent in a way that promotes smart growth principles. Any
So
questions?
this is sort of like, in some ways, motherhood and apple pie, but I'm wondering, is it just a question of timing that we're talking about I guess it's to the sponsors of the bill, that we're talking about these principles applying to people who receive COVID relief funds as opposed to any other grant funds?
Aisha?
Yeah, I'm unmuting just to, I mean, I think originally the overall impetus for some of these sections was hearing the commissioner say, we just give us the money that is coming through the door from the federal government and we want to get it out. And this was a way to say, let's put some guiding principles around that. But I think, we don't know the types of federal dollars we're going to get and if they're labeled as COVID federal dollars. We don't know what money is coming. So I'm very open to like, is this too narrow at this point? It didn't feel that way like 6 months ago, but that's probably when we started drafting it.
Okay.
And may I just add, I'm assuming that all our incredibly enlightened agencies who know so much more about housing than most of us are already operating under this value and under this principle. So there is no question in my mind that VHCB and DHCD, everybody's operating under smart growth principles. But this sort of, I think, just wants to say it out loud that any project that, and I would expand it to any, anyway, we could discuss it, but any COVID or Build Back Better money but I think we should discuss that, because really any major housing investment at this point should be supporting our smart growth principles, anyone. But at this point in time, it is, I think, just underscores that this is what we would hope.
Well, yeah, they are principles. I just get concerned, and we'll talk more about if this section survives. I would like to know the legal ramifications. I mean, are we setting ourselves up for, an individual citizen going to court and saying, you didn't promote compact growth to the fullest extent possible? Words matter, and this is a statute. So, another alternative that might be a different approach, and I don't know if it would be equally effective, is to have, when these grants go out, a template of some sort where, like we do for administrative rules, where they say how you've reached out to the public or how you've extended flexibility in this rule. And so in each case, they have to say, this is how we met these criteria. So at least they're forced to look at it, pay attention, but not necessarily have a litmus test of whether the project could go forward or not. Anyhow, we'll talk more about it. So let's move on.
The next piece is been around for 4 or 5 years. Most recently, I believe, manifests in H93, the Homeless Bill of Rights. And this is, numerous sections, rather than go through them each individually, because they appear in different places in the statutes. But in a nutshell, this, you're probably familiar with this. This is an anti-discrimination bill, and from work and employment to housing to places of public accommodation, etc. The purpose of this is to say that you can't discriminate against a person based on their housing status.
Okay, so could you tell us, David, I know that we really haven't touched upon this issue in our committee, but I think there's been extensive work in Tom Stevens' committee. Has there been, as far as you know, any discussion of this in that committee this year, and how far did they get in previous years?
I think that it was on their agenda this week. This is a bill that originally Luke worked on, and Luke has since, of course, moved west, and Damien has picked this up. So at this point, this is actually a Damien bill. And the last I saw, he was on the schedule to discuss this with House General this week, and that's really all I know.
Okay.
So the only thing I'd say is, Tom Stevens and I worked on this together in House General in 2011.
Is that
They
right?
certainly picked it up, more recently, and I think tried to fine tune some of the sections that were a struggle for shelters, etc. And I let them know informally, the leadership of that committee, that this was in the bill here. So that might, I didn't know that had spurred them perhaps to look at it again, to know that it's in conversation in both committees this time.
Good.
I apologize, Senator Ram Hinsdale, for not being aware that you have been working on
Okay.
this for
It's a
much
long time
longer
ago.
than 2017. I was just trying to do a quick
2011.
it's come up in different as different bill numbers. So I think 93 is the most current one, but that could also be an error. The next few sections are each appropriations of federal COVID funds for housing related purposes, whether incentives, support services, etc. They are targeted at different areas. Obviously, the devil would be in the details, and the dollars are something, that's what committees do. But as concepts, Section 5 relates to first generation home buyers, right? So this would be, as of now, it's 5 million through DHCD to work in coordination with VHFA and other stakeholders to design and implement a program to provide grants not more than $10,000 for purchase and closing costs to first generation home buyers. So that's first generation home buyers. That's not the same thing as first time home buyers. And that's the distinction I want to draw here.
So, Senator Ram, I guess, would this equally work in our downtown down payment assistance program and add this money there with a carve out for first generation home buyers? Do we need to, can we just, at least that program has defined guardrails and parameters at this point. This is fairly open-ended. And if we didn't do a lot more work on this, we'd be in that situation where we'd be just giving money over with and letting the administration design the whole program. This is sort of like what we faced in like VHIP and other programs that got money but didn't pass into law.
Yeah, I think, if VHFA and Mara Collins come in to explain the areas where they feel like there's a big gap in the current tools they have available, then they might make the case, and the committee might want to look deeper into this and make the language much more specific and functional to actually get to the people it's supposed to get to. I mean, this would mean 500, grants for homeowners, but Maura would also be the first to say it feels like with the first generation, the first time homebuyer tax credit, it's smaller. It leaves a lot of people behind who don't have other generational wealth to draw from to fill in to put the pieces together. And this, while we have the dollars, let's make it a grant instead of a tax credit, which also doesn't help everyone, particularly people who don't have generational wealth. So she, I think, could be a better champion for this, knowing where the gaps are that she's been seeing.
Okay.
But of course, I agree with you. We don't want the money to be set aside and then languish or not get to the right people. So we had talked about the details being really important. Eventually, how do you determine a first generation home buyer? How much money is a solid amount for that person? And how do we get it quickly into the hands of people who are trying to buy their first home?
Okay. Well, we'll definitely have more in on that one.
And yeah, there are other parameters too to consider. So I look forward to having more, but I would always hope that this was done in concert with VHFA's other programs. So not to be created separately, but to enhance and create more opportunity within that program.
Right.
And for more people, and maybe in anyway, I think there's lots to discuss actually in this.
Okay. David, what time did you say you had to?
11.
11. Okay.
He has 6 more minutes or 7 more minutes.
Okay. Let's keep going.
Sure. So Section 6, similar construct, federal dollars through DHCD, and this would be working with VHCD and stakeholders. So this relates to manufactured home relocation assistance. There's a lot more detail here starting on page 29. So this is money to for grants to help with moving abandoned homes, building, code compliant concrete pads for existing homes, help with small scale capital needs for mobile home parks. Two is grant funds for rehabilitating existing substandard homes. 3 and 4 sort of advocacy and marketing components of manufactured homes and promotion and support of those communities. 5 grants for common home repairs for sort of small scale, just improvements that are necessary, not quite the same as rehabilitating substandard homes, rather helping with just the cost of maintenance and upkeep. The next piece, we're identifying and providing funding for gaps such as ADA compliance, independent living accessibility, moving homes out of floodplains and other dangerous locations to new lots. Also in 7, supplementary funds for flood resilient communities. It just gives grants to buy out of floodplains, also relocation services, new infrastructure for new sites. 8, down payment assistance and purchase of high energy efficiency mobile homes to replace older homes. 9 would be funding to parks themselves for, basically park improvement and infrastructure beautification, public space, road repair and maintenance, etc. So that money all flowing through DHCD and VHCD to help mobile home owners and mobile home parks in a lot of different ways. I'll leave it there.
Great. Thank you, Senator Rahm, for pulling this together. It seems like touching upon a lot of areas of concern for mobile home parks and mobile home tenants. Okay, let's keep going. We have about 4 minutes.
Sure. 7 is money through DHCD to design and implement a program to provide matching funds on a per employee basis to employers with 25 or more employees when that employer is providing housing for its workforce. So this is basically a matching grant program to help employers provide housing.
I just want to say, when we say provide housing, that could probably be parsed a little bit more so it doesn't make it seem like we're incentivizing them becoming the landlord in any way, but knowing that a lot of larger institutions are trying to put money toward development where they know that their workforce could live without being the one holding the management or, ownership of the property, or at least have articulated that this could really change the availability of housing where there's crunches due to institutions like hospitals and colleges.
Are you familiar with any other state or municipality doing something like this, and whether it was brought to your attention at all in the form of a tax credit to employers? They can claim that they gave $5,000 towards a deposit or a down payment, and therefore they want to claim a credit. I mean, there's a lot of different ways of incentivizing this, and I'm just wondering, obviously we all in this committee, I think, like the idea of incentivizing relocated workers, and part of the targeting of that money goes to first month's rent, deposits, and things like that. this could get some matching funds from employers, which I think is great.
Yeah, I sort of just I just started with the need, that I heard that a lot of these housing crunches are in areas where there's an institution that,
Right.
has a lot of churn with people coming in and out, and they would be interested in helping be part of the solution, but could use seeing the state put some skin in the game. So I mean, and you're on finance, so if a tax credit seems more feasible because it's a but for kind of, we wouldn't have this development. That could make sense. I just think,
Don't ever use the word "but for" in this committee.
Fair enough. Yeah.
No, but no, we know like Bennington Hospital is trying to buy units, and yes, that's a great idea. If we can get partnerships with some of these things by offering some incentives, it's definitely worth considering.
Yeah.
I got about 1 more minute until I have to pop out and I can come back. But I'll try to finish up. Are you seeing section 8 on your screen?
Yep.
Okay, so this would be a commercial property conversion incentive. That's basically DHCD working with RDCs, RPCs, chambers, etc., to identify commercial properties that could be efficiently converted to residential use and provide grants on a per project basis to purchase, rehab, and convert those types of properties.
Okay.
Section 9 is New American Housing Support Services. So this is money flowing through DHCD actually to contract with one or more entities to provide financial support, translation, legal, technical services, and other housing related services to Vermonters who are new Americans.
Okay. TIF is Becky's, right?
It is, and it's an extension of some of the existing districts, and I'm not even gonna begin to try to explain it.
Perfect. We'll let you go, David. Thank you so much. This has worked
Sure.
out just as I hoped, actually. So let's take a 10-minute break now, and we'll come back and hear from Chris if he's around, and then we'll talk about 157 when David comes back. That's the home construction fraud bill, and the House has now offered us a proposed amendment. So
Okay.
see you in 10 minutes at